Landmark case on affirmative action, the Supreme Court of Appeal struck down the use of racial quotas in determining job appointments. Joining us now to discuss the implications of the case is Dirk Groenewald, head of the Solidarity Center of Fair Labour Practices, as well as Leon Lowe, Executive Director at the Free Market Foundation. Gentlemen, thank you so much for your time today. I'm a black female and I'm somebody who's very keen on being appointed into a job that I have the necessary skills and requirements for and qualifications for, not just because I'm black and I'm female. So a case like this, when I first read about it in the newspapers last week, it took me by a bit of surprise, Leon, as to how it would come about in the first place. Maybe you could take us back slightly and paint a picture for us. Well,
let's start by understanding the history, of course, which is how you always start with the mantra of the history, which is apartheid and inequalities, and the desire to fix that, to make it right. Now, what happens is people get guided by their own interests. So as you started off by saying, if people think they will be beneficiaries of a policy, they support it, which is why, for example, white Afrikaners supported apartheid, and now black South Africans support what might be called reverse apartheid. After all, apartheid was simply affirmative action for white Afrikaners. Now, the other thing is people identify with their interests, but also with their group. For example, agricultural land redistribution in South Africa will benefit virtually no black South Africans. Very, very few, 0.001% might actually get a farm. So it's never going to benefit you. But people support their group. So, for example, Jews support Israel and Arabs support Palestine, even though they themselves will never be beneficiaries of either. So that's firstly how human beings come down on this issue. You come down on the side according to those criteria. The other one, of course, is our Constitution. And our Constitution has one very, very simple clause. And it says there shall be no discrimination of any kind. No quotas, no discrimination. Except this, that the government may take measures to protect and advance people who are disadvantaged, not in the past, not historical, not black, but anyone who is disadvantaged, according to the Constitution, as a result of unfair discrimination, the government may take measures to advance and protect them. There is nothing about the private sector, nothing about charters, nothing about blacks, nothing about anything other than whoever is in fact disadvantaged now in the present tense. So any elites, for example, don't qualify. Any people that are doing quite well, like you, don't qualify. But nonetheless, there is this belief that somehow measures should be taken to bring about equal outcomes in South Africa, not equal rights or opportunities in South Africa. So that's what's going on over here. This is interpreted as justifying quotas and discrimination and all sorts of things, which we understand. I mean, the history, you'd have to be oblivious to history if you don't understand how people reach those conclusions. Whether they're right and fair and just is what the court ruled on and said it's not fair. It's not fair, it's not just, and it's not fair to the beneficiaries of the services. That's important. The court said a lot about that. Very important. It's not just a case between the two people who are discriminated for and against, but the public who get inferior services and protection, most of whom are black. So black South Africans will become the victims of irrational and unfair discrimination, according to the court. That was their finding.
I agree with you completely there, Leon, and I think for me the emphasis should be placed on skills development. You get a group of people who are at disadvantage, not previously or currently disadvantaged as a whole, and you encourage skills development there. From your perspective, Dirk, this is no doubt a precedent-setting case.
Definitely. I mean, for us, this court case opens up a lot of cases. We're currently representing 27 individuals which have basically the exact same facts. They've also applied for positions. They've been found to be the best candidates for the positions. They've been recommended by the panel. Deviations was sent up in some circumstances to the National Commission. In the case of Mrs. Barnard, the Divisional Commissioner made a formal recommendation and an application as to why Mrs. Barnard should be appointed. And then in most cases you see that the head of that department or the head of that service then just decides, well, we're not going to appoint, basically due to the fact that the appointment will not enhance employment equity. Now, we find it totally unacceptable that if you go and look at the Constitution, you see that the Constitution says that we must be broadly representative. The Employment Equity Act says we must be equitably represented, and then we are faced with a situation where government departments go and look at the economic active population and decides to enforce that number on an absolute basis. And the court said that if you have an employment equity plan in place and if you enforce it in such an absolute manner, it will become a quota which is prohibited by the law. So we are engaged with a number of court cases against the SAPS, the Department of Correctional Service, and a number of state and semi-state institutions. And this court case definitely opens up, for us the way to start negotiating, hopefully, with these departments to see if we can come to a amenable solution as to how employment equity should be implemented.
No doubt. I wish we did have a lot more time to flesh this out just a little bit further. But Leon, just quickly to get your views on this, what does this mean for people who have been previously appointed on a quota basis in their positions? Should they
well, it has very potentially far-reaching implications. Not only can they now try and have those unfair discriminations, if that's what they were, reversed, but they can seek back pay and compensation. And having said that, by the way, what fascinates me is we have no race classification in South Africa. So who decides who's white and black? You know, when I've had to fill in classification forms, I've described everyone, Themba Nolachungu as Indian and Joan Evans as black and me as, Asian or whatever. And I want someone to challenge me. I do not understand how it is that people presume to be able to racially classify everyone else. They're not carrying out pencil tests and they're not carrying out DNA tests. There is nothing in our law or our constitution that entitles anyone to undertake race classification in employment policy.